Welcome to the 294th District Court. At all times while you're in the courtroom, please observe social distancing, make use of the entire courtroom. If you need a mask, do not have one, just ask. One will be provided to you. Please do not group up in the hallways or in the stairwell, restrooms, elevators. Be mindful of those around you and your surroundings. I'm going to call the cases this morning. When I call your name, I need you to say present or here. Raise your hand so I can acknowledge you for the docket. And I'm going to, once we call all of the cases, then I'm going to start recalling those of you who are present. Attorneys and clients in the courtroom will be called first, and then we will move to our Zoom cases. William Ivy, Dash Moore, Jaden Freely, Stephen Gandy, Mr. Gandy, I want you to come see the pretrial release department. My records indicate that you did not report in November. So, well, come on over. You can talk to her about that, and she's going to give you a urinalysis drug test while you're there, just so that you have no Christmas surprises. Jeremy Hendricks.
With counsel, Your Honor, via Zoom.
Thank you, Mr. Harrison. Miranda Hatton. Miranda Ann Hatton. John Lee Hawley. Thank you, Mr. Mayor Leader. Philip Maroney. Philip Ray Maroney. Mr. Mayor Leader, you know anything about Mr. Maroney?
Your Honor, last time I spoke to him, he was correct.
Thank you, sir. Tasha Morris. Ms. Morris, at this time, if you'll come report to pretrial release, and then I'll recall your case. Dylan Schroeder. And Mr. Mayor Leader, my docket reflects that he's to appear via Zoom today.
That's correct.
I'm not sure if he's in our waiting room, but we'll check in just a moment. Michael Reisner. Austin Harris. Christopher Templin. Stephanie Goss. Stephanie Lynn Goss. Kirkland Huggins. Alicia Joyner. Alicia Renee Joyner. Mr. Schmidt, any word, Ms. Joyner?
Judge, I haven't heard from him this morning, but as soon as you're done calling talking, I'm going to see if I can track these folks down.
Kimberly Marshall.
Here.
Michael Watkins.
Here.
Marcus Gardner. Thank you, Mr. Weiner. Jacob Howell. Brittany Alvizo. Brittany Nicole Alvizo. Mr. Jeff White here. Do you see Mr. White?
His stuff here.
Okay. Maybe speaking with her. Scott Bowden. Nicholas Fincher. Marcus Fowler. Mitchell Autry. Mitchell Autry.
I have not heard from Mr. Autry sometime. I'll approach the page and talk to you with that.
Okay.
That's certainly called.
Willie Jopling.
You know, Mr. Joplin is coming from Garrison.
Katrina Lambright. Miss Lambright, I need you to report to pretrial release before I call your case again. Oh, she already has. She's good. Miss Lambright, you're good. Dustin Sorrells. Mr. Sorrells, if you haven't checked in with pretrial release, come and do that at this time. Gennaro Laredo Trejo. Gennaro Laredo Trejo.
Judge, we haven't heard Trejo. I don't expect it today.
You don't expect him today? Should I cancel the Spanish interpreter? For sure. If you want to make
It could be 4.
contact with, you want to make contact, just let him know that he's free to go that way if he has other hearing. All right, counsel who's present in the courtroom. Anyone's ready? Ms. Beasley? If you'll step to the podium. Jaden Freely? If you have a cell phone that keeps going off, you need to turn it off. Right there to that middle podium, Ms. Freely. All right, Ms. Beasley, I'll show that Ms. Freely is set here today on status of her PTI. Is that correct?
That is correct, Your Honor. And we've signed the amendment to her contract this morning.
Remind me what that's all about.
She's to serve some jail time. She reports to the jail at 6 p.m. on Friday and is released at 6 p.m. on Sunday as condition of probation, or the contract, sorry.
Okay. Court to approve that? Is that to be brought to my attention, or is that just something you've done with the state?
That's something I worked out with Ms. Hillary.
You need
Yes, Your Honor. We're going to reinstate Ms. Friedley's PTI after her 1 weekend of sanctions. That is the agreement.
Okay, so you don't need anything from the court then at this time?
Judge, I believe that if Ms. Friedley has signed the amendment to conditions of probation, we would just need your signature on that. But other than that, that should take care of the business today.
That's been done, Your Honor.
Who has that?
He has a copy, and
Has it already been signed? So you don't need the court signature. All right, you're free to go, Ms. Freely.
thank you. Have you excused, Your Honor?
Yes, yes, ma'am.
Thank you.
I'm assuming that the PTI was modified to include interviewees.
Yes, Your Honor.
Thank you. Mr. Weiner, you ready?
Yes, Your Honor, on both my cases.
Marcus Gardner, if you'll make your way to the center podium, please. All right, Mr. Gardner set for pretrial today, is that correct?
Yes, Your Honor, it's true.
And we have no contested pretrial motions for the court this time, Judge.
All right, this is CR 2161, CR 2162. Just one moment. docket call on January 26th on each case.
Yes, Your Honor.
Yes, you're free to go, Mr. Gardner. We'll see you back on January 26th.
Thank you, Judge.
Your Honor.
Mr. Weiner, who else are you ready on?
Jacob Howell. Same page, Judge.
Mr. Howell, CR 2083. Mr. Howell set for pretrial today.
Actually, I believe he's set for docket call, but regardless, we had no pretrial on this matter. I've spoken with the state. We're working towards resolution. There are some unindicted cases they've given me access to discovery to, and I have some mitigating information I'm going to furnish to them so that hopefully we can resolve this case. So I'd ask to be set for another docket call or a first docket call.
Let me check into the docketing why mine says pretrial.
I had thought it was set for pretrial. Maybe I misread the docket earlier, but oh yes, I guess I misread the docket, Judge. It is set for pretrial. But we have no contested pretrial, and I think we're ready to move to docket call, Judge.
All right, the court will set Mr. Howell in for docket call also on January 26th.
Yes, Your Honor. And I discussed the email from the court coordinator regarding his previous court-appointed attorney fees, and he's going to be working towards paying those.
And I showed that he has made a payment towards those, so
Yes, sir.
we got progress.
Thank you, Judge.
Mr. Schmidt, are you ready?
On one, Your Honor. Austin Harris.
Austin Harris, CR 20166. Docket shows he's set for docket call today.
It is, Your Honor. We've come to a plea agreement with the state. However, that will necessitate them filing a misdemeanor information and complaint information. And then as part of the plea agreement, the indicted cause would be dismissed, and we're requesting that the court set this for a plea on January 12th if possible, so they can do that paperwork.
Can't do the 12th. We're already at 60 cases that day, so that's maximum capacity for this courtroom. We have the 26th available.
Judge, the 26th is great.
All right. Mr. Harris, you're set for January 26th for plea at 9 a.m. Mr. Smith's going to provide you a notice of appearance. Once you sign and receive the yellow copy, you'll be free to go.
Thank you, Judge, and we're working on paperwork on the other case.
Yes, sir.
Can I interject something, Your Honor?
Just 1 second, Mr. Platt.
Thank you.
Go ahead, Mr. Platt.
Your Honor, I had originally thought that my client's setting was for yesterday rather than today, and I have a conflict at 10 a.m. with TDCJ. I just wanted to inform the court of that.
Yeah, I'm ready if you're ready.
I'm ready.
Mr. Reisner? And Mr. Platt, I'll need you to put a jacket on the next time you appear in court.
Well, I apologize, Your Honor.
I tried to send you a message, but you must not have seen that. All right, Mr. Reisner, this is CR 20-139-140. I show that we're set for pre-trial today. And Mr. Platt, I noticed that you filed a motion for continuance, and in that motion stated that you did not have all the discovery from the state. And so I wanted to have a hearing and make a record about that. What is it that we're missing?
Your Honor, I think some of that has gotten cleared up. I believe that there still is there are some body cameras that aren't available just yet. Ms. Heisel just got this case, and we started talking about it on, I think it was Thursday or Friday, one of the two. I think it was Thursday. And I have the videos that I did not have, but what I learned is that there's some additional body cam footage. This is a pretty big case here. And like I said, I don't have any contested pretrial at this point in time. But if this were placed back on the docket for the 26th, I think that we would know exactly what direction we're taking.
Do you know specifically which body cams you're missing so we can put it on the notice of appearance so the state's clear on what you're requesting?
There was additional body cam footage from the Grand Saline Police Department. Officers.
You know officers or?
It was the investigating officers that took the statements. They also had body cameras.
Do you know who those are, Ms. Heisel?
Orgus or?
Your Honor, to my knowledge, Mr. Platten has everything that we have, but I will follow up with those officers and confirm whether or not there is additional video available for the state and defense.
And Your Honor, to add on to that, all the media that I have is apparently on a USB. I don't show any record of any DVDs. Everything should be on a flash drive, which was sent to Mr. Platten in October.
Mr. Platt, was it from your review of that discovery that you believe that there's additional body cam footage that was not provided?
That's correct, Your Honor. They set a body camera down on the desk, and they even informed the witnesses that it was being recorded by body camera as well.
And so the video, so you have a video of the interview, but there's also a body cam that was present in that interview.
Present in the interview, and I believe carried around whenever they left the rooms.
Okay. State, do you feel like you've got sufficient information now to determine whether or not, if there is that body cam video, that it can be produced?
Yes, Your Honor. I do recall the body camera from the interview and those statements being made, and I will follow up to see if that is available.
Okay. Court will then set this for an additional pretrial on January 26th at 9 a.m.
Yeah, I emailed that last week.
Bailiff's going to have Mr. Reisner sign the notice of appearance and give him the yellow copy, and he'll be free to go.
Thanks for taking this out of order, and I will have a jacket next time.
Thanks, sir.
Good day.
Very good. Zoomed in for a moment. So he's still here. Yes, once you have your yellow copy, you're free to go, Mr. Reisner.
Thank you, Your Honor.
Do we have any other counsel that present in the courtroom that's ready?
Your Honor, I'm ready.
Okay.
So,
And Your Honor, I'm ready. My client's in the courtroom. I'm not. So whenever the court's ready.
Yes, sir.
you want to take up Mr. Harris, Your Honor?
Let's go ahead and start with what you got, and then we'll take up Mr. Harrison.
Your Honor, we're going to resolve Mr. Joplin's case, but we've got a whole
we've got some restitution. I need to talk to Mr. Cox about how we're going to deal with that real quick. It's Miss Heisel's case, but I guess I'm ready to go on Mr. Sorrells.
Dustin Sorrells, CR 2090. Mr. Sorrells, if you'll make your way to the center podium. Yes, thank you, Mr. Weiner. Mr. Sorrells, my docket says he's set for docket call today.
Your Honor, we're going to ask the court to reset this for a plea. Ms. Heisel and I have talked about this. I believe we've got an agreement.
Ms. Heisel, is that correct? You'll have an agreement?
Yes, Your Honor.
All right. Court will set Mr. Sorrells then for plea on January 26th at 9 a.m. All right, Mr. Sorrells, have you already reported to pretrial release, correct?
Yes, Your Honor.
Okay, once you got that yellow copy, you're free to go. Are you ready on Ms. Lambright?
I am, Your Honor.
Katrina Lambright, CR 20-175-176. Set for docket call today, Mr. White.
Yes, sir. State and I are still trying to work through this and issues come up. I don't really know anything about this. I think there's a possibility, and I talked to Ms. Heisel about this, that maybe the court will coordinate possibly witness in this. But we talked about being able to
You just requesting reset?
yes.
About how long do you think you need to talk to the state? Yeah, and that's January 5th. Does that give you enough time?
It should, Your Honor.
All right, Ms. Lambright, you're free to go. We'll see you back on January 5th. Anyone else that you're ready on, Mr. White? Or do you need more time on Mr. Joplin?
I'm going to need Mr. May I approach her?
Yes, and Mr. Autry's not here, right? Mitchell Autry? All right, Mr. Harrison, are you ready? I believe you're on mute, Mr. Harrison.
Sorry, Judge. Yes, I am ready. And since this is a Monday through Friday, I'm going to go ahead and be in my jacket.
Thank you, sir. I appreciate that.
Yes, sir.
Mr. Hendricks, you'll make your way to the center podium. CR 28-1, State versus Jeremy Ryan Hendricks. I show that we're set for a plea today. Is that right?
That's correct, Your Honor. A plea to a lesser included.
Take just a moment to review the paperwork here, Mr. Hendricks. All right, I believe that we'll need to get Mr. Hendricks sworn on his signature to the plea paperwork. So it'll be just a moment. Let me recall the case in just a minute, Mr. Harrison, after the clerks can come in here.
Yes, Your Honor.
Clerks come in and swear Mr. Hendricks. Mr. Burleader. So Mr. Hendricks, just have a seat. I'm going to call your case again. Oh, sorry. Mr. Burleader, who are you ready on? Good morning.
Miss Tasha Morris.
Miss Morris, go make your way to the center podium, please. This is CR 2220, State versus Tasha Jean Morris. I show that we're set for pretrial.
That's correct, Your Honor. We have one outstanding pretrial issue. We filed a motion to suppress. We would like to have that set for an evidentiary hearing. At this point, I think Ms. Heisel has offered deferred for her case, but Ms. Morris has rejected any plea and would also request a jury trial after the evidentiary hearing.
But we'll take that up after the evidentiary hearing, or at the time. So we're going to set this for a hearing on your motion to suppress. You filed that prior to 7 days before today's hearing.
I think I filed it last month, Your Honor.
Yes, Judge. The state has received copy and reviewed the motion.
All right, so we'll set this for motion to suppress hearing on January 28th. And that will be at 9 a.m.
Thank you, Your Honor.
Mr. Burleader, anyone else?
Yes, Your Honor. Miss Miranda Hatton.
Ms. Hatton, Miranda Hatton. This is CR 2167, set for pretrial.
Yes, Your Honor. We have all the discovery in the case. We have no pending pretrial motions. Ms. Hatton was given a pre-indictment offer of 18 months state jail, probated for 3 years, community supervision with a $1,000 fine. That was rejected before indictment, and we haven't received any kind of a plea offer since. But Ms. Hatton has not requested me to get a plea offer, and she would request a jury trial.
So she's ready to forego any additional time to negotiate with the state, and she wants to move directly to jury selection.
That's correct, Your Honor.
She understands that if by making that choice, if the state were to make a better offer later, the court may not be inclined to let her accept that.
That's correct, Your Honor.
Ms. Hatton also understands that once she's placed on jury selection, she will be reporting to the courthouse once a month and will continue to do so until her case is reached for trial.
That's correct, Your Honor.
That may mean if the Supreme Court does not allow us to have any more jury trials for a year, that would mean she would be reporting every month for a year.
That's correct.
All right, then we'll have Ms. Hatton report for jury selection on February 1st. And Ms. Hatton, you'll report downstairs 8:30 a.m. in the basement of the courthouse, and you'll receive further instruction from court staff at that time.
Thank you.
And Ms. Hatton, I need you to report to pretrial release before you leave.
Philip Maroney, Your Honor.
Mr. Maroney? CR 2219, Mr. Maroney set for docket call.
That's correct, Your Honor. Mr. Maroney's discovery on this case is complete, and I've been in plea negotiations with Ms. Heisel, but Ms. Heisel informed me that he was indicted for a new offense, CR 20-00348. We haven't received the discovery on that new offense yet, Your Honor. We just received the notice of arraignment for that. Judge, we're going to file a waiver arraignment and request a discovery for that, and we'd like to resolve both cases at once. So I'd like to request a reset, Your Honor, for pretrial for this case as well as the CR 20-00348.
Do you recall when CR 2348 is set for arraignment?
No, but I can quickly check. January 12th at 9 a.m.
And it was your intention to request a waiver on that date and request a pretrial in February?
That's correct, Your Honor.
All right, court will set Mr. Maroney then for an additional docket call on February 9th. Maroney, before you leave, I need you to report to pretrial release. Mr. Merleader, anyone else?
Yes, Your Honor. Mr. Dylan Schroeder, he's probably in the waiting room on Zoom.
Let's see if this is he. Mr. Merleader, it doesn't appear that I'm not sure if this is your client or not, but it doesn't look like it's connecting. I'll tell you what, if you want to touch base with him,
Yes, Your Honor.
I'm going to put him back in the waiting room and maybe touch base.
Yes, Your Honor.
Mr. Harrison, are you ready? Mr. Hendricks,
Yes, Your Honor.
come on back up, sir. Let's try this again. Thank you. This is CR 28-1, State versus Jeremy Ryan Hendricks. And Mr. Harrison, have you already reviewed Mr. Hendricks' conditions of community supervision with him?
Judge, I'm not sure I had them physically. We discussed the fact that he would have to review those today, though. We've gone over the standard conditions.
Should I have any concern that Mr. Hendricks would not understand what's expected of him prior to entering this plea?
No, Your Honor. He understands very well what's expected.
All right, Mr. Hendricks, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Are you Jeremy Ryan Hendricks?
Yes, sir.
And Mr. Hendricks, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Brett Harrison. Are you pleased with his representation of you?
Yes, I am.
Do you feel like you've had sufficient time to talk with him about your case and have all of your legal questions answered?
Yes, I do.
Is there anything about the paperwork that you've reviewed and signed that you do not understand?
No, sir.
And Mr. Harrison, do you believe Mr. Hendricks to be competent today?
I do, Your Honor.
And have you explained to him his legal and constitutional rights?
I have, Your Honor. We've been able to meet both in person and by phone on many, many occasions, and we've gone over everything that he's doing today, any possible defenses, and how best to resolve his case.
Thank you, Mr. Harrison. I see that Mr. Hendricks was originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon, but the plea before the court is a reduction of that charge to that of a Class A misdemeanor deadly conduct, and then a recommendation of a deferred finding of guilt with 2 years community supervision and a $1,000 fine, $270 court costs, and $35 reimbursement fees. Is that the plea agreement as you understand it, Mr. Harrison?
It is, Your Honor.
Mr. Hendricks, is that your understanding as well?
Yes, sir.
Mr. Hendricks, the range of punishment for a Class A misdemeanor offense in the state of Texas for deadly conduct is confinement in the Van Zandt County Jail for up to a maximum of 365 days and a fine not to exceed $4,000. You understand that range of punishment?
Yes, sir.
You understand that if the court approves this plea agreement, places you on community supervision, and later finds that you violated the terms and conditions of your community supervision, the court could adjudicate your guilt, that means find you guilty, could revoke your community supervision, and could assess your punishment anywhere from 0 days up to 365 days in the county jail, and also assess a fine up to $4,000. Do you understand that?
Yes, Your Honor.
And this is the plea agreement that you want to accept and move forward with today?
Yes, Your Honor.
All right, Mr. Hendricks, then to the Class A misdemeanor offense of deadly conduct, how do you plead? Guilty or not guilty?
Guilty.
Mr. Hendricks, are you pleading guilty because you are guilty of that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Harrison, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. Hendricks' judicial confession. Is there anything further from the state?
No, Your Honor. Rest and close.
Anything further from the defense?
No, Your Honor. We rest and close.
state, is there any victim impact statement or? Yes, please. All right, based upon the court's review of the evidence, the court will find that there is sufficient evidence to convict Mr. Hendricks of this offense. However, the court will follow the plea agreement as reached and recommended by the state. The court hereby defers a finding of guilt in this matter, places Mr. Hendricks on 2 years community supervision, assesses a $1,000 fine, court costs of $270, and orders reimbursement fees of $35. The court also certifies to the defendant this date that this is a plea bargain case and the defendant has no right to appeal. Mr. Hendricks, have you been on probation before?
Yes, sir, I have.
And you successfully completed or unsuccessfully completed?
I successfully completed it.
So you understand what's expected and required of you?
Yes, sir, I do.
You understand that if you violate a single term of your community supervision, it's possible that you can be brought back before the court. And if the court finds you violated, then the issue before the court is not whether or not you committed deadly conduct. It's whether you violated the terms of your community supervision. You understand that?
Yes, sir, I do.
And if you violate, you understand the court can assess your punishment up to 1 year confinement in the county jail.
Yes, sir.
All right, Mr. Hendricks, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward to be fingerprinted by my bailiff. After that, you're to report to the Van Zandt County Probation Department over here with Ms. Burns. Okay. Anything further, Mr. Harrison?
No, Your Honor, that's all the business I have, if I may be excused.
Yes, sir. Thank you. Appreciate it.
Thank you, Your Honor. I won't see you again. Have a good holiday,
Thank you. Merry Christmas.
everybody. Thank you.
Mr. Schmidt, are you ready? You ready on Christopher Templin?
Yes, Your Honor.
Mr. Templin, you'll make your way to the center podium, please. This is CR 2196, State versus Christopher Lee Templin, set for docket call.
It is. We've reached a plea agreement, Your Honor.
We're going to enter that plea today.
Yes, sir.
All right, Mr. Templin, if you will, raise your right hand, sir. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. You are, in fact, Christopher Lee Templin, is that right?
Yes, sir.
And Mr. Templin, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Brian Schmidt. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this plea agreement that you've read and signed that you do not understand?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, sir.
And you've also explained to him about the terms and conditions that will be required of him if the court places him on community supervision?
Yes, Your Honor.
Mr. Templin, you are charged by indictment with a third-degree felony offense of driving while intoxicated, a third or more offense. A third-degree felony carries a range of punishment of not less than 2 or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
Do you understand that if the court approves your plea agreement and places you on community supervision, if during that term of community supervision, if you violate any one of your conditions, that the state may file a motion to revoke your community supervision, could bring you back before the court, and if they prove that to the court that you violated, the court could sentence you up to 10 years in prison.
Yes, sir.
You understand that? And you want to go forward with this plea today, is that correct?
Yes, sir.
Then, Mr. Templin, to that charge of a third-degree felony offense of driving while intoxicated, third or more, how do you plead? Are you pleading guilty because you are guilty of that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
Yes, sir.
The court accepts Mr. Templin's plea of guilt at this time. Mr. Schmidt, any objection to States 1?
No, Your Honor.
States 1, stipulation of evidence is admitted, and the court takes judicial notice of Mr. Templin's judicial confession. Is there anything further from the state?
No, Your Honor, rest.
Defense?
Rest and close, Your Honor.
All All right, Mr. Templin, based on the court's review of the evidence, the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. The court hereby convicts you of driving while intoxicated, third or more offense. The court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will find it's in the best interest of the community and yourself for that sentence to be suspended. The court places you on community supervision for 3 years. Court orders you to pay a fine of $2,500, court costs of $290, and orders you to pay a reimbursement fee of $35. Counsel, just remind me, there's no statutory minimum days confinement required on a third or more probated offense, is there?
As a condition of probation?
Yes, sir.
I think there is, actually, Judge.
Dave, are you, Ms. Heisel or Mr. Cox?
I didn't catch that question.
Just, I'm looking for a refresher on, is there a minimum term of confinement on a third degree felony offense?
Yes, Judge, 10 days.
Yeah.
10 days. Do we know if that's reflected, and is Mr. Templin aware of that?
Judge, I'm not sure it's actually in the conditions of probation. I didn't think about that, but I concur. There is a minimum 10 of 180 days of condition of probation. Part of the plea. I'm sure Mr. Temple will be, if I could have just a moment with
Yeah,
him.
what we'll do is we'll just take a pause for a moment and let you speak.
I've spoken with the state and my client's still in agreement with the plea bargain agreement. The state is not opposing allowing him to do weekends, if that's acceptable to the court.
I don't believe it's a requirement that it be continuous 10 days like the 72 hours, correct?
Correct.
That's correct, Your Honor.
Court has no objection to the weekend. However, I believe we'll need to get a separate order of commitment for the jail to rely on, so Mr. Templin can take that with him. Since it's not in this paperwork here, we can just have this separate order.
Yes, Your Honor. And just for the record, we'll present the court with an agreed confinement order for my client to go in January 1st at 8 p.m. It would be out Monday, January 4th by 6 a.m. and for consecutive weekends thereafter until he completes the statutory minimum 10 days. If that's acceptable.
That's acceptable to the court. I didn't write that down, so the state
Yes, sir.
will need to produce that.
Well, and
we'll need to amend the conditions of community supervision to show that.
okay. Your Honor, I'm going to send the dates to Miss Abney for the DA's request, and she's going to prepare a confinement order for the court. And we can fill in, if there's something in the probation conditions, I can fill that in with my client and have him initial it, if that's acceptable.
Mr. Keating, Ms. Burns. We're going to need Mr. Templin's conditions of community supervision modified to include 10 days confinement in the jail. Mr. Schmitt's going to have the date and times. So I'm going to give these back to you. So let's just do this. Let's just recall him back up in a moment. We'll complete it all at once.
Okay.
I believe do we believe Ms. Abney can have that produced relatively quickly?
Yes, Judge, I'm sorry, yes.
Okay.
Sometime this morning.
I thought you were waiting on Miss Heisel. Miss Heisel stayed on mute, so I knew she wasn't going to say anything.
I'll step over and be supervision.
Yeah, Mr. Templin, if you want to just have a seat and we'll come back in a moment. Mr. Schmidt, if you'll get those dates to Miss Burns, and then if you'll give it Miss Hatton and get the in order. Mr. Schmidt, are you ready? You received an appointment today, is that correct?
When the court called this morning's docket, Ms. Goss was still writing. She's here today. Ms. Joyner is also
Stephanie Goss. Ms. Goss, if you'll make your way to the center podium, please.
Judge, the judgment, the fines didn't match. The fines in the actual fine amount, the fine of the fee itself was incorrect. I lined that out and put the appropriate amount.
Just at the last page of the probation conditions. Walk through that, right?
Yes, sir.
All right, are you Stephanie Lynn Goss?
Yes, sir.
Ms. Goss, if you'll raise your right hand, please, ma'am. Ms. Goss, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, please put your hand down. Make sure you speak up as loud as you can so my court reporter here can take down what you have to say, okay? Ms. Goss, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Bipolar, PTSD, depression.
Are you currently on any types of medication for those disorders?
Yes, sir.
Are you on medication today?
Yes.
Do you feel like that medication assists you in having rational thoughts so that you can understand the proceedings against you today?
Yes, sir.
And you're not having any type of confusion or any other issues related to those disorders at this time, is that correct?
No, sir. Yes.
Ms. Goss, have you had sufficient time to discuss this case with your attorney, Mr. Schmidt, have all of your legal questions answered?
Yes, sir.
Are you pleased with his representation of you?
Yes, sir.
Is there anything about this plea agreement that you do not understand?
No, sir.
Mr. Schmidt, do you believe Ms. Goss to be competent today?
I do, Judge.
Ms. Goss, you are charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. That type of offense carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and also a fine not to exceed $10,000. Do you understand that any punishment handed down by the court or a jury in this matter would have to fall within that range?
Yes, sir.
Now, I see that there's a proposed plea agreement between you and the state wherein you're going to plead guilty to that offense, and the state's recommending to the court that the court review the evidence, find that there's sufficient evidence to convict you of this offense, but to defer a finding of guilt in this matter and place you on community supervision for a period of 2 years. Also, a fine of $2,000, court costs of $290, and reimbursement fees of $570.
Yes, sir.
Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Schmidt?
Yes, sir.
Then, Ms. Goss, let me ask you at this time, how do you plead to abandoning or endangering a child with criminal negligence?
Guilty.
And Ms. Goss, are you pleading guilty because you are guilty of that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or made you feel like you had to plead guilty to this offense?
No, sir.
All right, the court will accept Ms. Goss's plea of guilt at this time. Mr. Schmidt, any objection to States 1?
No objection, Judge.
States 1 is admitted into evidence, and the court takes judicial notice of Ms. Goss's judicial confession. Is there anything further from the state?
No, Judge, pressed and close. I wasn't sure if Hillary was going to take that one or not.
Anything further from the defense?
No, Judge.
Mr. Schmidt, is there any update for the court on any standing CPS matter regarding Ms. Goss and the victim of this offense?
Judge, it's my understanding that Ms. Goss is in compliance and participating with CPS ongoing. In addition, the child is in Smith County with her father, but she is in compliance with the requirements and the plan that has been set out by CPS.
Ms. Goss, do I need to lecture you today on the danger and the harm to a 4-year-old child testing positive for methamphetamine?
No, sir.
4-year-olds don't know how to cook meth, and smoke meth, and inject meth, right? They don't know how to do that. They need others to do that for them. And you did that. You did that for your 4-year-old, didn't you?
Yes, sir.
Ms. Goss, I'm gonna follow the recommendation of the state here. And I hope for your sake that you take advantage of this plea agreement that Mr. Schmidt and the state have worked to give you. However, I'm gonna caution you that if there's any other opportunity that you appear before the court and there's similar allegations such as this involving you and methamphetamine or your child and methamphetamine, the outlook's going to be bleak for you. So if you have a drug problem and Mr. Schmidt says that you're complying, and I hope that's the case, if you're not, you need to be.
I'm reporting to rehab this afternoon.
Ms. Goss, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in this case. The court defers a finding of guilt in this matter places you on community supervision for a period of 2 years, assesses a $2,000 fine, orders you to pay court costs of $290, and reimbursement fees of $570. Ms. Goss, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you step forward to be fingerprinted with my bailiff, and I want you to report to the probation department. You ready on Joyner?
Judge, I'm ready on Joyner and Ivy. Mr. Huggins would be a plea waiting on the paperwork. So those two I'm ready.
CR 20127, State versus Alicia Joyner. Is Ms. Joyner set for docket call today?
Is, Judge, I discussed with the state a request for an additional docket call. There's some things that Ms. Joyner brought to my attention that I need to investigate. I would like to believe that it would have an impact on the resolution of her case. We would request the court reset this matter for an additional docket. Hopefully they'll resolve it.
Any objection from the state?
No, Your Honor.
All right, Ms. Joyner, I will reset your case for an additional docket call on January 26th at 9 a.m. Ms. Joyner, you were late today. I called your name and you weren't here.
No, I'm sorry.
So what I did is I wrote down, issue a warrant for Alicia Joyner. That's what I wrote down.
I'm
Do you
sorry.
want me to mark that out or do you want me to leave it?
No, you can mark it out.
The only way that I'm going to mark this out in the future is if you show up at 9 o'clock when I call your name.
Yes, sir.
Did you report to pretrial release yet?
No.
That's because you weren't here at 9 o'clock. If you were here at 9 o'clock, I would have told you you need to report to pretrial release so you can sign to show that you're here so that a warrant doesn't get issued for your arrest. Do you understand?
Yes, sir.
So after Mr. Schmidt gives you that notice of appearance, I need you to report to pretrial release. Really, are you still working? Are you ready? You said Huggins would be at moment, right?
Okay, I got Ivy too.
Ivy, okay, just a minute, Mr. Elliott. Mr. Ivy, you'll make your way to the center podium. Have you received the indictments?
I have, Judge, we've reviewed them.
This is cause numbers CR 19, 313, 314, 315, and 316. State versus William Dwayne Ivy. Mr. Ivy, you requested the court to review you for appointed counsel. The court has reviewed your application, has found you to be indigent, and has appointed Honorable Richard Schmidt to appoint you. I believe you've met Mr. Schmidt this morning. He's present in the courtroom with you. Mr. Schmidt, are you ready for arraignment?
I am, Judge. I've gone over the indictments with Mr. Ivy and all causes. His name is spelled correctly. We would waive for formal reading of those indictments. Enter a plea of not guilty, ask the matter be set for a pretrial date. And Judge, I would notify the court that based on the nature of the charges, I suspect that there'll be a significant amount of evidence to go through from the state. And I would ask maybe for a little bit more time between now and pretrial than the court would normally set.
Mr. Schmidt's correct about a significant amount of evidence to review.
will set Mr. Ivy then for pre-trial on February 23rd in each case at 9 a.m. Mr. Ivy, have you received conditions of pretrial release?
Yes, sir, I'm going over when I leave here.
You're going over to the pretrial release department. Have you received those conditions though?
Yes, sir.
You have? Okay. If you've received those and that yellow notice, you're free to go. Let's see here. All right, Mr. Templin, you'll come back to the center podium. Before we got,
There's actually, we
completed everything you needed to
yeah, I think we,
go over the confinement order.
you actually had found him guilty.
Mr. Templin, do you understand you're still under oath? Mr. Templin, during your plea, the court found you guilty of that offense and told you that it was going to follow the plea agreement in this case, which was the recommendation of 10 years confinement in the Texas Department of Criminal Justice, suspended and placing you on community supervision for a period of 3 years. It was after we had that discussion that it occurred to me to inquire about any kind of legal requirement that you report to the Van Zandt County Jail as a condition of your community supervision. And you were present in the courtroom at that time, and I believe that you've had a chance to speak with your attorney, Mr. Schmidt, about the additional 10 days confinement in jail that's required as a matter of law for this type of offense. Have you had enough time to consult with Mr. Schmidt about that? Do you have any questions about that?
No, sir. Everyone's fine.
And you understand that it is a requirement under the law that you serve an additional 10 days in the Van Zandt County Jail. And the court is approving your commitment to the jail for weekend commitments beginning January 1st through January 4th, in by 8 p.m., out by 6 a.m., and continuing on the following weekends, January 8th and January 15th, in a light course until you satisfy all 10 days. You understand that?
Yes, sir.
You understand that if you do not submit yourself to the jail to be committed, that would constitute a violation of your community supervision also. You understand that?
Yes, sir.
And you still want to move forward with the plea, is that correct?
Yes, sir.
Mr. Schmidt, anything else?
No, sir. No, sir.
All right, so just to be cautious, the court hereby, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Templin of this offense. The court hereby convicts Mr. Templin of the third degree felony offense of driving while intoxicated, third or more offense, third degree felony, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, suspends that sentence for 3 years, assesses a $2,500 fine, $290 court costs, $35 reimbursement fees, orders him to serve 10 days confinement in the Van Zandt County Jail as a condition of his community supervision. Mr. Templin, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to go ahead and have you step forward here to be fingerprinted with the bailiff. After that, I want you to report to the probation department. And I will let you know that whenever you go to the jail to be committed for your weekend commitments, that you need to bring a picture ID with you. And you also need to bring a copy of your judgment and a copy of this special order for commitment to jail. If you do not bring those items, they will not put you in jail. Okay? And then they will report back to me that you didn't show up with those things. I won't be pleased and you won't be pleased. Okay? All right. And I want you to stick around today. Probation will be able to give you a copy of this. Make sure you do not leave without a copy of your judgment and that special order. Okay?
Thanks, Judge. Sorry about that.
It's okay. Does that conclude your business?
It does, my big shoes.
Yes, sir. Good to see you.
You too, Judge. Thanks.
Mr. Elliott, I told him he was up next, but he slipped away. So, Mr. White, are you ready? Let's do your non-please first.
Okay. First one's on the docket is Dashmore.
Dashmore, CR 16376. Mr. Moore set for motion to revoke today.
That's correct, Your Honor. I wound up giving some information to the district attorney's office last week. They told me, Mr. Woodward told me that he would like to have some more time to be able to look over what I gave him.
No objection from state.
No, Your Honor.
All right, court will reset Mr. Moore. January 26th. That'll be at 9 a.m. Mr. Moore, just want to remind you that you are still on conditions of community supervision. Okay? That means you still have to report, you still have to pay.
His time has expired.
Oh, has it expired?
Yes.
Okay, so the motion was filed before the expiration?
Yes, sir.
Issue. Okay. All right, then you can disregard what I said.
Yes, sir.
Okay. But we'll see you back on January 26th at 9 a.m.
Yes, sir.
All right, free to go.
The other one that is a reset is two cases, Marcus Fowler.
Mr. Fowler, CR 2159. All right, Mr. Fowler is set for docket call today.
Well, Your Honor, I'm going to need another reset on this. I just received the offer today. And also the DVD, one DVD worked, the other DVD didn't. I don't know if it has anything to do with the computer system that I have or if there was a malfunction in the DVD, but the bottom line is I didn't get to see one of the DVDs.
Any objection from the state?
No, Your Honor, that's my fault on the offer. It's slipping through the cracks, and I just got this spring. Mr. Fowler was just. No objection.
All right, Mr. Fowler, court's going to reset your case at January 26th at 9 a.m. Docket call.
Maybe pre-trial docket shows docket call.
I believe it really was the pre-trial. I've already filed my regular motions, but I believe it was a pre-trial just in case I needed to find something on the DVDs.
Were both cases indicted at the same time?
That's correct.
show that on September 17th, there was a waiver of arraignment granted. Pretrial on October 13th, pretrial again on November 12th, and then docket call today.
Well, either situation, the bottom line is I'm going to need a little bit of time to be able to get the DVD in.
That was on CR 20159.
They both kind of run together. It's CR 20160 and 159 had basically the same time.
I'm either losing my mind or I was looking at the wrong case.
Yeah, I believe this is like the 5th setting for Mr. Fell. He was indicted in July.
Well, it's still my fault for just now getting him an offer.
Yeah, the court. Yeah, court's going to grant.
One of those dates I wound up missing because I was in quarantine.
Yeah, court's going to grant the request. We'll set Mr. Fowler for January 26th at 9 a.m. You're free to go.
Do I need to talk to my pretrial probation?
Yes, go ahead and check in with them, please. All right, Mr. White.
Pitcher and Alviso are both ready to go as far as please.
Do I have paperwork on either of those?
It's over here.
Has it been sworn? Been to clerk? I don't believe this has gone to probation yet. That would be probation. Yeah, so. That real quick. Addition to probation. Yeah, go ahead. Then he needs to go over those conditions. It's future. Heisel?
Yes, Your Honor.
Looking at this Nicholas Fincher, and here's a petition for reimbursement. It looks like the drug. This is the restitution form. Is that right? Do y'all usually sign that, submit that?
Yes, Your Honor.
Have Mr. Cox sign that?
Yes.
Yeah, Mr. Cox. Nicholas Fincher. Mr. Fincher, if you will, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Are you Nicholas Christopher B. Fincher? Is that correct? And Mr. Fincher, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you?
Fully.
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this plea agreement and the paperwork that you've reviewed and signed that you do not understand?
Yes, sir.
Mr. White, do you believe Mr. Fincher to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor. I believe he's competent to make the decisions that he's made today and understand what he's talking about.
Do we have probation conditions on this case? All right, Mr. Fincher, you've been charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, but less than 400 grams. That carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice Institutional Division, and also a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
You understand that if the court approves the plea agreement that you've reached with the state to place you on deferred community supervision for a period of 5 years, that if you violate the terms and conditions of your community supervision and the state proves that to the court's hearing would be limited to whether or not you violated a term and condition of your probation, not whether or not you possess controlled substances on May 17th of 2019. Do you understand that? That if the court finds that you violated, the court could assess your punishment up to 20 years in prison. You understand that? I mean, that's a pretty serious decision. You understand that?
Yes, sir.
You do?
Fully. Yes.
All right, Mr. Fincher, to the charge of possession of a controlled substance in penalty group 2, 4 grams to 400 grams, how do you plead? Are you pleading guilty because, in fact, you are guilty of that offense and for no other reason? Meaning you're not pleading guilty just so you can get this deferred. You're pleading guilty because you're guilty of committing this offense.
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
Yes, sir.
Court accepts Mr. Fincher's plea of guilt. Mr. White, any objection to states 1?
No objection.
Stipulation of evidence is admitted as states 1. The court takes judicial notice of Mr. Fincher's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close.
From the defense?
Nothing, Your Honor.
All right, Mr. Fincher, based on the court's review of the evidence, the court finds that there is evidence to convict you of this offense, and the court hereby follows the plea agreement in your case. Court defers a finding of guilt, places you on community supervision for a period of 5 years. assesses a fine in the amount of $4,175, orders you to pay restitution in the amount of $180. The court dismisses under section 1245 unfiled misdemeanor numbers M19-639, resisting arrest, and M19-369, possession of marijuana less than 2 ounces. The court also orders you to pay court costs of $290 and reimbursement fees of $35. Mr. Fincher, have you been on probation before?
No, sir.
No?
I did have a no insurance ticket.
Say that again?
I had a no insurance ticket, and I'm pretty sure they gave me probation, like a 90-day probation.
You've never been on probation where you've had to report to a probation officer, pee in a cup, keep a job, do your community service?
No, sir.
You know, be an adult?
No, sir, but I know how to be an adult.
You understand that it's easier to get handcuffs put on you and put in a cell and told when to use the bathroom, when to eat, when to sleep, than it is to be an adult, be responsible, be productive, hold down a job, don't be a drain on society. You understand it's easier to go to jail than it is to do this? Are you sure you can handle this?
I'm positive.
You understand if you can handle it, then you'll put me in a position to handle it for you.
Yes, sir.
Understand that? If you've got a drug problem, I suggest now would be the time that you come to grips with that and try to get that fixed. Otherwise, you may be sitting in prison for up to 20 years wishing you had taken my advice. My recommendation for you is to meet your probation officer, make friends with them, do everything they tell you to do.
Sir.
Right? Otherwise, the government's going to be in your life. The government's going to be in your life for the next 5 years, regardless. If you don't know what the government looks like, you're looking at him. Okay?
Sir.
All right, Mr. Fincher. You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence and have you step forward to be fingerprinted with my bailiff. Mr. Elliott, are you ready? Are you ready?
Yes, Your Honor.
All right, Mr. Gandy, slip on down here. Come on down to the center podium. Let's see, this is CR 2120, State versus Stephen Paul Gandy. Mr. Gandy is set for pretrial today. Any contested pretrial motions?
No, Your Honor, I've talked to Mr. Cox with the state, and 2 of the videos are partial and they're okay. And then there's 2 more videos that I can hear but I can't see. And I need to have an opportunity to be able to go to their office and try to sort that out. I don't know why that is, but I've had that on more than one case. Sometimes the videos work perfect, but on this case, I've got 2 that I can only hear but I can't see. So I need to be able to try to get another court date on that. I don't think Mr. Cox is going to object. So if I can get another date on that, then I believe there's probably going to be an announcement from the state.
All right, court will set Mr. Gandy for an additional pretrial on we'll go February 9th. Do you have a notice of appearance, Mr. Elliott? Do you have any do you have any conflicts on that?
I'm trying to get my, it's spinning.
Not working for you.
It's trying. I'm
fine on the 9th. What time?
9 a.m. That's great. Just give him the yellow one, and then we'll keep that white one. All right, and the court had Mr. Gandy undergo a hearing analysis because I showed that he had not reported in November as a condition of his pretrial release. Do we have any update on that?
We do, Your Honor.
What is that?
I'll defer to Mr. Gann.
The allegation is medicine or anything of that nature that could cause a false positive commitment.
He denied any medications. He advised. He's claiming it's been a month since he left.
Your Honor, if I can respond to that.
Go ahead.
Mr. Gandy is informed that it's been over a month since he's used, and that it's been at least a month since he's been around anyone else that he knew of that had used. With the holidays coming up, we would request that he be allowed to even report weekly, whatever he needs to do, have this set out until the results can come back after they reach the lab. I don't know if that would come back before or after Christmas, but that's our request.
State have a position.
Ms. Heisel, do you have a position? Well, Judge, my position is, even if it has been a month since his last use, he was still on conditions of pretrial release a month ago. So even if it has been a month, that would still be a violation of his pretrial release.
Judge, the conditions were entered in October. He says that it's been over a month, but he believes it's been since before he came to court.
What is Mr. Gandy's bond right now?
For some reason, it's not entered into LGS. Let me see if I can find it, Your Honor. I'm sorry.
It's okay. I'm looking at the clerk's office. I believe right now it's at $50,000.
We believe that's right, Judge.
Yes, sir.
That's what I show as well, Your Honor, $50,000 with A Springer.
Mr. Gandy, I don't know what to do. My gut tells me to revoke your bond, find it insufficient, something of that nature, put you back in jail. That's what my gut tells me to do. Come back over here and have a seat. Let me think about it a little bit more. Mr. Elliott, if you'll approach. Ms. Hasley, can
Sorry, Judge.
you hear me okay?
Yes.
Okay. I'm just going to have Mr. Gandy hang out for just a second. It'll be just a few minutes. Just a few minutes.
That's fine.
Is there anything about your plea agreement that would state that you do not understand?
No, sir.
Mr. Murray, do you believe Mr. Hawley to be competent today?
Yes, Your Honor.
To explain to him his legal and constitutional rights?
That's correct, Your Honor.
Mr. Hawley, it looks like you were indicted with the third-degree felony offense of deadly conduct by discharge of a firearm. However, it appears to the court that you've entered a plea agreement with the state for a lesser charge of a Class A misdemeanor offense of deadly conduct. In exchange for your plea of guilt, the recommendation is that punishment be assessed at 3 days in the county jail, for which you would receive credit for each day served, a fine of $2,000, and dismissal of indicted cause number CR 2214, deadly conduct, discharge of a firearm. And then the state's going to be rejecting or resolving unfiled F-2017 and F-2018, and aggravated assault, and also abandoning a child. You'd also have court costs of $270 and reimbursement fees of $915. Is that your understanding of the plea agreement?
Yes, sir.
Yours as well, Mr. Murray.
Yes, Your Honor. And Mr. Hawley is prepared to pay that today.
Pay what?
His fines, court costs, and
Okay, good. All right, Mr. Hawley, then the range of punishment for a Class A misdemeanor is confinement in the county jail for up to 365 days and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, Your Honor.
And the plea agreement here fits within that range of punishment, so the court will take notice of that. Mr. Hawley, to the Class A misdemeanor offense of deadly conduct, how do you plead?
Guilty, Your Honor.
Are you pleading guilty because you are guilty of that offense and for no other reason?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
No.
The court accepts Mr. Hawley's plea of guilt. Mr. Murleader, any objection to State's Exhibit 1?
No, Your Honor.
State's Exhibit 1 is admitted into evidence, and the court takes judicial notice of Mr. Hawley's judicial confession. Is there anything further from the state?
No, Your Honor.
For the defense?
Yes, Your Honor. On the issue of the firearms, so our agreement today does not reflect the 4 firearms that were confiscated from Mr. Hawley, and I just wanted to put on evidence about those 4 firearms.
So there's no agreement to forfeit or to release?
I believe the state is asking to forfeit the 9mm, which we've agreed to. And we've asked for return of the 20 gauge firearm, which the state has agreed to. But on the 2 remaining firearms, the state is still That's correct.
That's the case.
Wait, his sister.
Okay. The issue, Your Honor, is that Mr. Hawley is a convicted felon. It has been 5 years since release from confinement and or community supervision. Provided that those other 2 firearms are indeed registered to his sister, I'm free to return them to his sister. We're just waiting on a check. Once we get that confirmation, Mr. Murray and I are going to present the court with a separate property disposal order where Mr. Hawley will forfeit the other 2 weapons and we will agree to release the other 2.
Just so everyone's clear, there's nothing in the paperwork reflecting weapons at all.
There's nothing in there right now. Just for we wanted to put that on the record so the court is aware of any outstanding issues.
Anything further?
Nothing further, Judge.
So my understanding is y'all reached an agreement with return of 1, forfeiture of 1, and then we're waiting on the other 2 to see what the status is and whether or not it can be released, Mr. Hawley.
That's correct, Judge.
Mr. Hawley. Based on the court's review of the evidence, the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement as recommended by the state. The court hereby convicts you of the Class A misdemeanor offense of deadly conduct, assesses your punishment in 3 days confinement in the county jail. Court awards you credit for 3 days of time already served. Court orders you pay a fine of $2,000, $270 court costs, $915 reimbursement fees. Court dismisses file caused CR 20214 under Section 1245 of the Texas Penal Code. Court also finds that there's agreement that unfiled causes F 2017 and F 2018 are taken into consideration. This clause. All right, Mr. Hawley, hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And have you step forward to be fingerprinted. After that, you'll be free to go, and I'd order you to go across the hall and pay your fines and fees today. That was the agreement. Is that correct, Mr. Leader?
That's correct, Your Honor.
Let's go ahead and step forward with the bailiff here.
Approach off the record for another issue.
Yes, yes. Mr. Gaines, you'll come to this podium. Court's going to go back on the record on cause number CR 2219, State versus Philip Ray Maroney Jr. It's been brought to my attention through the pretrial relief department and through Officer Larry Gann that Mr. Maroney did not submit to the urinalysis exam that I ordered him to complete this morning. Is that correct?
That's correct.
And can you just give me some information surrounding that? Let me do this. Let me go ahead and swear you in, Mr. Gann. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth. So if you got it.
Yes, sir.
Go ahead.
Mr. Maroney was advised that he was to submit to urinalysis. He was taken to the jury room. I went to answer a question by the clerk's office, told him to stand out in the hallway, and I'll be with him in just a second. When I returned back to the hallway, he was gone. I've walked all over the building looking for him, upstairs, downstairs, and he cannot be found.
The record will reflect that Mr. Maroney is not present in the courtroom at this time. Do you have any additional information, Mr. Maroney?
Judge, I was sitting outside in the hall talking to another client of mine, admonishing him on his plea when I saw Mr. Maroney standing outside. And the next moment I saw Mr. Gant. And he explained to me that Mr. Maroney had ran and he couldn't find him anywhere. So that prompted me trying to contact him through our office. And we got in touch with his mother and explained to her that if he doesn't come back to the court immediately, that the court is probably going to revoke his bond. We've had no additional contact with Mr. Maroney, and we have no indication that he's going to return to court. Subject to the court's ruling for the bond insufficiency or finding the bond insufficient, I would ask the court to keep open until this afternoon to allow Mr. Maroney to report, because he had been previously reporting to every single court date, and I was going to file a waiver and allow him to report on February 9th when the court set its next court date, so that we can resolve all the cases together. We're going to continue to try to reach out to him and explain to him that the court doesn't want to throw him in jail, doesn't want to increase the population. All it wants is to have him tested for part of the bond conditions. That's what I would ask him.
Well, the court, having already set Mr. Maroney for docket call on February 9th, will maintain that date. The court will find that Mr. Maroney has violated the terms of his pretrial release by failing to submit to a urinalysis as ordered by the court. The court's going to find Mr. Maroney's bonds to be insufficient at this time, and it's going to set new bail in the amount of $150,000. The court will have that warrant issued today. That's on cause number CR 2219. CR 2348 is an independent case, so that's not before the court today. Thank you, Mr. Gandy. All right, Mr. Elliott. All right, Mr. Gandy. All right, we're back on the record, CR 2120 on the issue of Mr. Gandy's positive for the field test on the urinalysis. Court is going to request that the probation department pretrial release and offer confirmation. Court is going to set Mr. Gandy for a hearing on January 5th. Do you have any conflicts on that date, Mr. Elliott?
going to be downstairs in the morning, so I can be here at 9.
We're going to set it for a status of the UA confirmation on January 5th. The court's going to amend Mr. Gandy's conditions of pretrial release to include weekly supervision until that time. Mr. Gandy, I'm not going to find you in violation today. However, we are going to take up this matter on January 5th. If there is confirmation that you have methamphetamine and it was during the terms of your condition of your pretrial release, then we'll take that issue up on January 5th. So I would strongly recommend is perhaps you get with Mr. Elliott and all with the state, determine if there's some kind of resolution you can reach to resolve your case. Otherwise, this hearing is going to be what's going to be on the forefront of my mind come January 5th.
Thank you.
You understand what I'm telling you?
Yes.
I'm going to have you report back here to pretrial release and sign these amended conditions, and you're going to report weekly.
Yes.
If you fail to report as directed, they're going to notify me, and then there's going to be a warrant issued for your arrest. All right, go ahead and go to pretrial release this time. And Mr. Elliott, if you'll assist the court, we need his notice to show January 5th, or we can write a new one, either way. We should have February 9th for pretrial and then January 5th.
Let me do another one. Is that all right?
That's fine, yes. If you'll just bring the white one back and give him the yellow one. Mr. Elliott, that'll be January 5th will be at 1:30. Wait, no, it's I failed to look at that. I think I may have said another one. Also,
Is there any other things that we
7th. All right, let's do 9 o'clock on the 7th. Is that Mr. White's? Well, we'll get Mr. Nolan on. Let him know that we'll need to modify that to the afternoon. All right, Mr. White, are you ready on this LB? All right, Miss Alviso. Alviso, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Are you Brittany Nicole Alviso? Are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Just bipolar.
And are you currently on any medication for that disorder?
Yes, sir.
Do you feel like that medication is assisting you today and giving you rational thought and understanding?
Yes, sir.
In this case, you are represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you? Feel like you've had enough time to talk to him about your case and have your legal questions answered?
Yes, sir.
Is there anything about this plea agreement that you do not understand?
No.
And Mr. White, do you believe Ms. Alviso to be competent today?
She's competent to make the decisions she's making today.
And you explained to her the her legal and constitutional rights, and also the advantages and disadvantages of a deferred adjudication plea.
We did, Your Honor, and she understands.
Ms. Alviso, you are charged by indictment with a third-degree felony offense of tampering or fabricating with physical evidence. A third-degree felony offense in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement. Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that?
Yes, sir.
You understand that if the court goes along with this plea agreement and you're placed on community supervision, if you violate any of the terms of your probation, then the court could sentence you to prison up to 10 years.
Yes, sir.
All right, Ms. Alviso, at this time, then, how do you plead to the third-degree felony offense of tampering or fabricating with physical evidence?
Guilty.
And are you pleading guilty because, in fact, you are guilty of that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt. Mr. White, any objection to States 1?
No objection, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, rest of those.
From the defense?
Nothing.
All right, based upon the court's review of the evidence, the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places you on community supervision for a period of 5 years. The court assesses a fine of $3,000, $290 court costs, and $35 reimbursement fee. Ms. Alviso, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. And have you step forward to be fingerprinted with my bailiff. After that, you're going to report to the probation department with Ms. Burns here. All right, Mr. Bowden. Mr. White, I believe this will go to Mr. Bowden. All right, are you Scott Allen Bowden?
Yes, sir.
This is CR 2103. Mr. Bowden, if you'll raise your right hand. Mr. Bowden, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Bowden, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had sufficient time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Anything about this plea agreement that you do not understand?
No, sir.
Mr. White, do you believe your client to be competent today?
I do, Your Honor. I believe he's competent to make the decisions that he's made today.
And you've explained to him his legal and constitutional rights and explained to him the advantages and disadvantages of a deferred plea?
He understands that he has right to a trial by jury, right to confront all witnesses. He's signed a stipulation of evidence. He also is aware that if he messes up, he's looking at 10 years in the penitentiary.
All right, Mr. Bowden. You're charged with a third-degree felony offense of theft of cattle, horse, or exotic livestock less than $150,000. That carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
Now, I see here that the agreement that you want to enter into with the state is that you'll plead guilty to that offense in exchange for their recommendation that I place you on deferred community supervision, which means that you would not receive a conviction for this offense so long as you successfully complete 10 years community supervision.
Yes, sir.
As a part of that community supervision, you're also going to have restitution ordered in the amount of $26,856.39.
Yes, sir.
Is that your understanding of the plea?
Yes. Yes.
Mr. White, any objections to that?
No objections to State's Exhibit 1.
No, I'm going to get there, but I'm saying that's your understanding.
Oh, that's my understanding.
Okay.
Yeah.
All right, Mr. Bowden, then, to that offense, how do you plead?
Guilty.
Mr. Bowden, are you pleading guilty to that offense because you are guilty of committing that offense and for no other reason?
Yes, sir.
Did anyone threaten you, forced you, or pressured you to plead guilty?
Yes, sir.
All right, court accepts Mr. Bowden's plea of guilt. Mr. White, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Judge.
Yeah, sure. Sorry. Yes, Your Honor. Just to clarify, there were 2 counts alleged in the indictment. Count 1 was with the victim named of J.W. Daly or Jimmy Daly. And count 2 was Casey Clark. Mr. Clark has since passed away, so the state is agreeing to abandon count 2 and proceed on count 1, with Dr. Daly receiving all of the restitution in this cause because it was his ranch that the cattle business was operated under. And so we are leaving it up to Dr. Daly there were actually 3 victims involved in the cattle company. We're leaving it to Dr. Daly to distribute that in proportion to their share of the business.
Thank you, Ms. Heisel. Anything further from the defense?
Nothing, Your Honor.
All right, Mr. Bowden, based upon the court's review of the evidence, the court will find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in this case that you've reached with the state. The court defers a finding of guilt. The court places you on community supervision for a period of 10 years, orders you to pay restitution in the amount of $26,856.39. The court does not assess a fine, does order court costs of $290, reimbursement fee of $35. And Mr. Bowden, you understand that if, while you're on community supervision, if you violate the terms and conditions of your community supervision and the state files a motion to adjudicate your guilt and revoke your probation, that the court will conduct a hearing and listen to the state's evidence. And if the court is convinced, then the court could find you guilty, revoke your probation, and sentence you in prison up to 10 years, anywhere between 2 years and 10 years. You understand that?
Yes, sir.
So probation is not easy. It's not a slap on the wrist. It requires work and responsibility and accountability. I hope you take it serious.
Yes, sir.
All right, Mr. Bowden, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. Have you stepped forward with my bailiff here to be fingerprinted? After that report, Ms. Burns here with the probation department. Mr. Murray Leader, are you ready on Linux, Michael Linux? Is that this afternoon? What about Mr. White? Did we plead Mr. Fincher already?
Yes, we did.
Okay, all right. I just did not mark that one. All right, let's see if we get Mr. Schroeder in here. Are you Mr. Schroeder? Mr. Schroeder, you may have to take your earphones out for that device to work. Because you're on mute, we can't hear you. I don't read lips either, so.
Does Estella read lips?
Judge, I think he's saying he can hear you.
All right, Mr. Schroeder, can you hear us now?
Yes, sir.
All right, if you'll go ahead and put that phone down and get still.
Yes, sir.
Thank you. All right, this is CR 2310, State versus Dylan Andrew Schroeder. We're set for pretrial today. Mr. Merleader, go ahead.
Yes, Your Honor. This is a newly indicted case. I believe was indicted in late October. We've sent over the discovery request, but we haven't received the video yet from the DA's office. And while this case was pending, Mr. Schroeder's got another charge for aggravated assault with a deadly weapon. I'm not sure if the state is going to indict that as well, but we've sent over the discovery request for that. Judge, at this point, we don't have a plea offer. We're just not ready in this case. I would ask for additional time so that we can figure out all these offenses and whether the court is going to hear an announcement of requesting a jury trial or a plea agreement between us and the state.
Say, what's the position and issue on discovery?
I'm sorry, I had somebody in my ear.
Ms. Heisel, are you addressing this one? And you're on mute.
Yes, Your Honor. I'm looking it up real quick for an answer for the court.
I had received the online discovery in the case, just not the video.
Did you request the video?
Yes.
When did you request it?
For the indicted case, we requested that on November 20th, but when I was appointed for this in October 2nd, I'd also sent over an LOR discovery request.
Judge, Ms. Abney typically puts case notes in there when the DVDs are prepared, and I don't see that for this particular case. So if we could get a reset, we will address that as soon as possible. And like Mr. Merleader said, it appears that the paper discovery is already up there. It's just the videos that we're lacking.
All right, Mr. Merleader, we will set Mr. Schroeder then for an additional pretrial on January 26th at 9 a.m.
get the reset notice to my client that he heard here.
All right, so Mr. Schroeder, you heard the court that you are set to appear on January 26th, right?
January 26th at 9 a.m.
January 26th at 9 a.m. And Mr. Murray Leader said he would get you a copy of the notice. This will be the only notice you receive from me in this court is here in person. Understand?
Yes, sir.
All right, we'll see you on January 26th at 9 a.m.
Yes, sir.
Judge, that concludes all the business I have for the court. I have two cases this afternoon.
Yes, sir.
I'll be back then.
Yes, sir. Mr. Steele, are you ready on Michael Watkins? You're on mute, sir.
No, Judge.
Mr. Watkins, if you'll make your way to the center podium. Mr. Murray Leader, if you'll slide out of the way. All right, this is cause number CR 2201, State versus Michael Watkins. Mr. Steele, I understand that you've been retained and have you filed a motion to substitute counsel for Mr. Jeff Wood?
I did. Well, Judge, I've sent it to Jeff Wood, and my understanding from my secretary is that it hadn't been sent back to me, but we have emailed the motion to Jeff. So hopefully that gets back to us soon.
Okay. And all right, so the court will grant the motion to substitute and will order Kyle Steele as the attorney of record for Mr. Michael Watkins. Court hereby removes Mr. Jeff Wood as appointed counsel. Mr. Watkins is set for docket call today. Are you ready for docket call, Mr. Steele?
Judge, I've received discovery, and I need to. I haven't had a chance to go over the discovery or talk to the district attorney's office. So I guess I'm asking for a reset.
What was the offer in this case, State, that was conveyed to Mr. Wood?
I'm getting there, Your Honor.
And while the state is looking that up, Mr. Steele, as we've discussed on your other cases where you've had to file a motion to substitute counsel, Mr. Wood will be submitting an invoice for the indigent fees that the court at the next hearing is going to inquire about whether or not your client has resolved that and paid the county what is owed to the county due to the appointment of indigent counsel.
Yes, sir.
I don't know, no invoice has been submitted yet. I don't know what that is, but maybe you can speak with Mr. Wood. I would recommend you speak with Mr. Wood's office, determine what that's going to be. Or
Yes,
you,
sir. Yes, Judge.
or you can inquire with my criminal court coordinator, Mr.
Okay.
Cox.
4 years TDC, Your Honor.
All right, so the offer at this time is 4 years Texas Department of Criminal Justice time. So I'm gonna set one additional docket call, Mr. Steele. And then on that docket call date, I will expect to hear from Mr. Watkins on whether or not he's going to accept that offer. There's counter offer that's been accepted, or the request for a jury trial or a bench trial. We'll set
Yes, sir.
we'll set additional docket call on January 7th. Do you have any scheduling conflicts on that day?
No, Judge, I'm set with my other two cases that day already.
Okay, good. That's what I thought. I wanted to try to get you all at once. All right, so that'll be at 9 a.m.
Yes, sir.
So my bailiff is having Mr. Watkins sign a notice of appearance. They'll have that date and that time on there for you. All right, Mr. Watkins, you're free to go. We'll see you back on January 7th at 9 a.m. Kimberly Marshall. Cause Cause number CR 2178. Go ahead, Mr. Steele, set for docket call.
Yeah, Judge. So we do have a signed motion to sub that's been e-filed apparently with a proposed order. And I do have paper discovery, and I received some media discovery in the mail today.
Okay, and what is the offer for Miss Marshall?
One moment, Your Honor.
Yes, sir. Meanwhile, the state is getting that for the court. My records reflect that Mr. Murleader, who's here in court with us, was court-appointed counsel. Court, if it has not already granted the motion to substitute, hereby orders that Kyle Steele is the attorney of record, and the court removes Mr. Shabnesh Murleader as court-appointed counsel. And Mr. Murleader has submitted a bill to the county in the amount of $582. The court, if it has not granted that, will be granting that soon. So, Mr. Steele, I'll need to have that addressed by your client before our next hearing.
Yes, Judge.
And any payments that she's made through our pretrial release will be credited towards that, but the court's going to be interested in addressing that sooner than later.
Thank you, Judge.
And Judge, this is Mr. Woodwike's case. There is no offer in our system. However, I'm unaware if they have been communicating by email, Mr. Woodwike and Mr. Murleader, about an offer. I will get with Mr. Woodwike and have him forward an offer to Mr. Steele.
All right, thank you, Ms. Heisel. Court will then set Ms. Marshall also on January 7th at 9 a.m. All right, Ms. Marshall, you're free to go.
Thank you.
Mr. Steele, is that all you have?
That's all I have today. May I be excused, Judge?
Yes, sir. Thank you. Appreciate it.
Thank you.
Mr. Schmidt, are you ready? Kirkland Wade Huggins, if you'll make your way to the center podium, please. Cox, I'll need you to sign this written plea of admonishment. the center stage. I'm going to put the spotlight on you. Mr. Huggins, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. All right, Mr. Huggins, you are Kirkland Wade Huggins, is that correct?
Yes, sir.
Mr. Huggins, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
Have you had enough time to talk to him about your case and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork and plea agreement that you have reviewed and signed that you do not understand?
Yes, sir.
Mr. Schmidt, do you believe Mr. Huggins to be competent today?
I do, Judge.
And you explained to him his legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea?
I have, Judge.
Mr. Huggins, you are charged by indictment with a first-degree felony offense of aggravated robbery that carries a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. Do you understand that?
Yes, sir.
Do you understand that if the court approves this plea agreement and places you on community supervision, that if you violate your community supervision, the state may file a motion to revoke and come in and present evidence to the court of a way that you violated. If the court finds that to be true, then the court could revoke your community supervision and could assess your punishment anywhere up to that maximum, 99 years. Thought about that and you considered it and you've spoken with your attorney about that, correct?
Yes, sir.
So you understand the seriousness of this agreement that you're entering into, is that correct?
Yes, sir.
How old are you?
I'm 19.
19. When did you turn 19?
May 23rd this year.
All right, Mr. Huggins, then let me ask you then, to that first degree felony offense of aggravated robbery, how do you plead?
Guilty.
And Mr. Huggins, are you pleading guilty to that offense because you are guilty of committing that offense and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
No, sir.
The court will accept Mr. Huggins' plea of guilt. Mr. Schmidt, any objection to States 1?
No, Judge.
States 1 is admitted into evidence and the court takes judicial notice of Mr. Huggins' judicial confession. Is there anything further from the state? From the defense?
No, Judge. We rest.
Is there any victim impact statement or position by the victim?
No, sir.
Okay. All right, Mr. Huggins, based on the court's review of the evidence, I find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in this case and the recommendation of the state. The court hereby defers a finding of guilt. That means the court will not convict you on this date. The court will defer a finding of guilt in this matter and place you on community supervision for a period of 10 years. The court assesses a fine of $1,500. The court orders you to also pay court costs of $290 and reimbursement fees of $1,285. Court orders you to serve 90 days confinement in the Van County Jail as a condition of your community supervision. The court is going to approve the special order of commitment for the times and days that you are to submit yourself to the Van County Jail. Mr. Huggins, do you understand that when you report to the Van Zandt County Jail, you need to have with you a copy of this order, a copy of the special order for commitment to jail, and a photographic ID so that the jail knows that you are who you say you are. And then,
Yes, sir. And do that every weekend.
say that again.
Every weekend, bring that.
Every time you go to the jail, you take your judgment, you take your special order of commitment, and you take a photo ID. Because if you present yourself without it, the jail may not let you in. And we're going to be checking to see if you show up and do what you're supposed to do. And if you try to go to jail and they won't let you in, then that's going to get reported back to the probation department. And if they tell us that you showed up without these things, then you're going to be in direct violation of my order to you. Just bring those things, you understand? State, I also need you to sign the certificate of discovery. All right, Mr. Huggins, do you understand the opportunity that's been given to you here today?
Yes, sir.
You understand that there's people that have stood in your shoes that have ended up going to prison for life? For life. And you know, a life sentence on an aggravated robbery means you would serve 30 years before you'd be eligible for parole. Do the math on that. 30 plus your age.
49.
Now, the better parts of your life would be spent in prison. You've got 10 years of this sentence hanging over your head. So the key to the jail cell is in your pocket right now.
Yes, sir.
That's what you need to remember. All right, you're the one that decides whether you go in or you stay out.
Yes, sir.
All right. If you violate the terms and conditions of your community supervision, you're committing any new offenses, that's going to be taken from you. Someone else is going to hold that. You understand?
Yes, sir.
I hope you walk out of here today and understand that your attorney, Mr. Schmidt, and the attorneys for the state have given you a golden opportunity to put this poor choice that you've made behind you and to move on with your life. They recognize that you're a young man and that we make dumb decisions in our youth. They're going to give you a chance to make up for that. Is this your family that's here with you today?
Yes, sir.
All right. You want them to be proud of you?
Yes, sir.
They're probably not very proud of you right now. But you have the chance when you leave here today to turn that around.
Yes, sir.
Understand? Can you do this?
Yes, sir.
All right, Mr. Huggins, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of your sentence. I'm going to have you step up here with my bailiff to be fingerprinted. After that, I want you to see Ms. Burns here with the probation department. Thank you, Mr. Schmidt. Appreciate it.
Some problems with our restaurant. So we're gonna end up having, they filled it out wrong at the bank. So he's gonna have to go back to the bank after lunch and then take it over. And he said we could go ahead and do this now, because he's got a cashier's check. He was
Not
just
paying restitution either.
paid out to the wrong entity that this guy has.
Okay. Mr. Jopling, if you'll make your way to the center podium, please, sir. All right, Mr. Jopling, if you will, raise your right hand, sir. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Are you Willie Paul Jopling?
Yes.
This is CR 252. Mr. Jopling, I hold in my hands a pretrial intervention contract that bears your signature. Have you had the opportunity to discuss your case with your attorney, Mr. White, and have all of your legal questions answered?
Yes.
Are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
And are you pleased with Mr. Nolan White's representation of you?
Yes.
Mr. White, do you believe Mr. Joplin to be competent today to enter into this contract?
Absolutely, Your Honor. I also believe that we've given up some rights in this, including the right to a speedy trial, right to a jury trial, and limited right to expunction. I believe that Mr. Joplin has executed those waivers knowingly, intentionally, voluntarily, with full understanding of what he's given up.
Thank you, Mr. White. All right, Mr. Joplin, it appears that you want to enter into the DA's and court's pretrial intervention program for a period of 1 year on the charge of theft of livestock less than 10 head with a value of less than $20,000 in hands, alleged to have occurred on April 16th of 2019. You've gone through this paperwork, you've signed it, and you have given away some important rights today. One of those rights being your right to a jury trial. In this case, you understand that you have the absolute right under the Texas Constitution to have this case presented to a jury of your peers for them to determine your guilt or non-guilt.
Yes.
And you understand by entering into this contract, you're going to be giving that up today.
Yes.
And are you doing so freely, intelligently, knowingly?
Yes.
Anyone threatened you or forced you to tell you that you have to give up that right to a jury trial?
No.
Court finds that the waiver of jury trial as requested has been joined in by the attorney for the defendant, Mr. Nolan White, and also, so Mr. Cox, can you sign this one here for me? The waiver of jury trial. Mr. Joplin, you're also giving up your right to a speedy trial, and as Mr. White has indicated, you understand that you are also giving up some rights with regards to certain expunction of certain records here in Van Zandt County. Have you discussed that with Mr. White? Do you understand that?
Yes.
All right. The court's going to approve the waiver of jury trial, finds that it's been entered in open court. The court also approves the waiver of speedy trial and limited waiver of expunction. Yes, sir.
It's a condition in the contract, Judge, that Mr. Joplin paid $10,000 in restitution. He went to the bank this morning and got a money order in that amount. Sent it over to our office and made that payment. However, there was an issue in order for that to be reissued. It's my understanding that Mr. White is going to take care of that before today. I just want to make sure we're on the same page there because it is a condition of this program. It's a condition of this contract that he make that payment to our office.
That's correct, Your Honor. We got a receipt here, and what had happened is I guess the cashier at the bank had made it out to the wrong entity, and so he's going to have to go back to the bank here at the Woodforest Bank in Walmart and have them reissue the money order. I don't anticipate there being any problem on that, but I'm not a banking person, so I'm not. But I mean, we've already tendered the cashiers to check as well as the PTI fee, so I feel okay that it's going to work out.
So, Mr. Joplin, you understand that whatever issue the bank may be having, that you may have to assist in making sure that that gets done so that the restitution gets paid.
I'll take it back over and get it done so later.
All right, the court finds that Mr. Joplin, having been advised of his rights, is intentionally and voluntarily entering into the pretrial intervention contract with the advice of counsel. And the court has approved the waiver of certain rights referenced herein. The court places Mr. Joplin on the pretrial intervention contract for a period of 1 year.
One other thing, Your Honor. Ms. Henson had texted me and asked me to inform Mr. Joplin to come by at 1:30 because that's when she'll be back from lunch.
right, Mr. Joplin, court's approved the pretrial intervention contract. So I'm gonna have you come over here and meet with Ms. Burns real quick, and she'll give you some additional information, and then you'll.
Okay.
That's part of the Constitution. Mr. White, is this yours?
Sure did. I'll take one for you. There's a, I guess I need to put something else on the record. I may have let
Thank you, Mr. Joplin.
regarding Mr. Autry.
Holding us in suspense here.
Court recall Mr. Autry's case briefly. I got something I put over the record.
And before I do that, let's state, are there any other cases other than Mr. Autry?
I'm gonna go to the last one on my docket.
All right. All right, court is going to stop the live stream at this time. We will resume the live stream